Good afternoon, and thank you for joining us today from your bubbles for a discussion on running a business in level 4. No doubt there'll be some discussion as well on what level 3 may well look like as well after the announcement this afternoon from our Prime Minister. I hope in opening that your families are all safe and well at this time. Today's live stream webinar is the 5th in a series of webinars that have been run by Godfreys Law. For those of you who may not know me, my name is Brad McDonald, and I'm one of the business owners at Godfreys Law. I've been with the firm for almost 20 years this coming September, and I've been involved in the running and management of the business for the last 12 years, so I've got some appreciation of what business owners go through on a day-to-day, let alone in these times. I'm an employment lawyer, but I also practice in the field of commercial law, and I will be the host for today's panel discussion. The invite to today's live stream webinar started with the tagline that it's a tough time to be running a business. And for once, I suggest the lawyer has not overstated things. What we're all facing with the COVID-19 global pandemic is quite simply unprecedented. There are, of course, many parallels in our current situation with what many of us experienced during the Canterbury earthquakes. Surviving the impacts of the earthquakes required strength and resilience to keep going through extremely challenging times. So in some respects, many business owners, including myself, have already faced and survived adversity on a large scale. And as much as there are parallels with the earthquakes, there are of course large differences, including the global reach of COVID-19 and the crippling impact on many businesses and industries with worldwide and local lockdowns. All of this has generated a tsunami of uncertainty for many business owners around employment law obligations and options, tax issues, commercial lease and rent provisions, cash flow, and almost every other part of a business's operations. It is not a stretch to say that for many it can all seem too much. The aim of the panel today, however, is to talk through some hot topics that myself and the panellists who are joining me today have been grappling with and helping our clients address over the last several weeks and also moving forward. With all great challenges come great solutions. Hopefully you may hear something today that helps you craft your plan for survival and success in these times. Hopefully you've had a chance to tune in and hear the Prime Minister give guidance this afternoon on what moving to level 3 will look like. No doubt the panellists here today will have some views on what this might mean for you in your decision-making processes moving forward. So turning now to introducing the panellists for today's live stream webinar. Today we have 3 experienced professionals on the panel, aside from myself of course. Firstly we've got Dorian and Crighton. Welcome Dorian. Dorian is from PKF Goldsmith Fox Accountants. He is a chartered accountant and is involved in all aspects of both business development and accounting-related services. Growing and supporting businesses is the key to Dorian's relationship with his clients. By aiming to achieve business success together with his clients, Dorian provides more than just down-to-earth accounting and tax advice, as well as a good dose of humour, but he assists in all levels of the business, your business, from strategic planning to the delivery. He has experience in construction and associated trades, with a special interest in developing successful businesses through planning, implementing efficient processes, and measuring success against key performance indicators. He also does quite a lot of work in the coaching, business owner coaching space, and I know he's very successful and highly regarded in that sphere. I've known Dorian pretty much the entire time I've been in practice, and recommend his skills and services unreservedly. Next up, we have Andy Ogilvie joining us today. Welcome, Andy. Andy is an Associate Solicitor at Godfreys Law. Andy's had a varied career, which means he's got many strings to his bow. He began his legal career as a clerk in the courts in Wellington and worked his way up to the lofty position of Registrar of the Court of Appeal before running his own business and studying law. Andy moved down to Christchurch in 2008, luckily sometime before the earthquakes, and now undertakes civil work in both the high and district courts, in addition to specialising in employment law, common law and traffic law. Debt recovery, liquidation and bankruptcy are also particular areas of expertise for Andy. And he does a lot of advice in that space. Andy enjoys pragmatically dealing with disputes with resort to court processes where necessary. And finally, today we have James Hobcraft joining us. Welcome, James. James is a solicitor with Godfreys Law and is the newest addition to our team, having just joined us in March. I'm sure he's wondered what the hell he's walked into. Outside the law, James is a business owner in his own right, and he has many years' experience in handling commercial disputes and negotiation. He possesses a unique skill set as he's been on both sides of the table on business and commercial matters, including having been a tenant and a landlord, an employer and an employee, as well as a creditor and a debtor. Haven't we all been there? This background gives James a full grasp and view of legal issues from both perspectives, which enables him to deliver meaningful and astute advice to the clients he advises. Alongside the provision of advice to clients in the commercial arena, James also specialises in employment law, and he completes the employment law team at Godfreys Law alongside myself and Andy Ogilvie. So they're your panellists today, so welcome. And before we get into the panel discussion and the presentations that the panellists have prepared for today, just got to go through the usual and oft laughed about lawyers disclaimer. And it also will apply to the accountant in the room today as well. So we're offering today's live stream webinar as a free service to give guidance and support to people at this time of greater uncertainty. It is an opportunity for you to ask questions of today's panellists relating to business issues that you are facing presently. And if you're watching today, you can pose a question through the Q&A function on Zoom, and the panel will do its very best to answer that for you. It's important, however, to understand that when you listen to the answers that the panel gives today, that those answers will be given to a specific question, often in the absence of all the background facts and documentation that might relate. Furthermore, some of today's panellists will be talking about proposed legislation. Where panellists are speaking today about proposed legislation, they can only talk to guidelines that have been made public. In most cases, we are operating on the same information that is available to all. Nonetheless, we are then applying our skills and experience to interpret and understand what it all means for your benefit, hopefully. Accordingly, you should not rely on the answers given by the panel today in this webinar to support a legal position that you might wish to adopt moving forward. Rather, any statements or answers given today are intended as guidance to assist with your general understanding of the landscape as we understand it here and now today. And you'll all be aware how quickly things have changed over the last 4 or so weeks in this scenario. So in closing on the disclaimer, you should always take detailed accounting or legal advice about your specific situation before acting or committing to any particular course of action. Rightio, so that wraps up the disclaimer from me. Thanks for your patience. I'm now going to hand over to Dorian first up to talk about the issues he's been grappling with and providing accountancy and business management advice to his clients at this time, alongside some thoughts on the immediate future that he might have. Over to you, Dorian, thanks.
Yeah, thanks, Brad, and for your kind introduction. Yeah, it is, the word unprecedented is sort of overused, and I did see somewhere where they're saying it isn't unprecedented, it's just unique. So, yeah, as you indicated, when we look at the advice that we try and give at PKF, it's really based around our mantra of supporting and growing businesses. So at the moment, obviously, we're really in the support phase. So we filter this through our values of being approachable, and that's one of the keys at the moment. It's trying to be practical and down to earth. And so I think a word that you used with me earlier today was pragmatic, and I think that's where we've got to be with a lot of the things that we're seeing out there. Generally, what happens about 1 o'clock, the government, Grant Robertson or Jacinda Ardern, makes some statements, and then my phone runs hot for the next hour asking if it applies to a business. So I guess where we've been sitting is supporting our businesses right through to ensuring little things like FBT. There's some, if the idea listening, there's some loopholes that we're working through there, right through to being part of the Business Regional Support Network and being a registered business there and providing COVID-19 special support and recovery packages through that. So there's a whole range of things that we're working through, but I guess the main things we're still being asked about is the subsidy, the loan scheme, and does it apply, and just generally looking forward through beyond the lockdown stages to where that cash flow lies, where does it leave the business when they come out the other side, as every business will. And I guess that's one of the things a lot of that I've been talking about is keeping people calm. Doing nothing is not an option, and the businesses that will come through the other side are working now, and I've been working with over the last week, working on their plan for getting out the other side. So realistically, that's where I've been working, a lot of that support space, and there's a lot of sort of tax work that comes alongside of that, but often you'll find that tax where it's ancillary to making a plan and making sure that you're forward thinking and just not thinking about where the next subsidy is coming from. So that's where we're sitting. We're seeing our most successful businesses actually working through and looking to the other side already, and adapting some of these systems and processes. In fact, even this morning before the announcement, I was on a coaching session with a client, and we were working through what her protocols might look like under level 3. So, you know, having those in place, I said there's a registration process that's going to be enacted, making sure that you can be one of the first people registered, enacted, so you can be up and running, not getting to next Tuesday week or Tuesday fortnight and going, right, I'm opening, right, now what do I do? So it's just making sure that you're always looking ahead. So that's a bit of a summary of where we've been working. Just as an aside, a bit of accountant easy stuff, technical stuff that I do. Just remember that the Inland Revenue are being very favourable on late paying, or as long as you make an arrangement or you're talking to them. They are not being particularly favourable on not filing. Okay, so just as a wee note that down, please. Make sure you keep filing your returns, even if you can't make payments. Okay, so that's just a wee word of warning about that. That's one place the ID can be a wee bit hot on. The reason for that is that they want the data to go back to the government. So that's why they're hot on that. But apart from that, yeah, that's what we've been working on. Yeah, thanks, Brad.
Awesome, thank you, Dorian. That's great to get a summary of what's been going on for you and your firm and your team at the moment, and picking up on the word pragmatic. I think we've seen a lot of that, and we've been using that word a lot with our clients since this lockdown began, whether it be in an employment law context or whether it be in a commercial lease context, and that pragmatism is really key. I think for many business owners, ourselves included, in navigating the current climate and what's to come. And it requires us to be nimble and responsive, and to be able to adapt, and that's going to be key to survival, I think. And that's going to require a good dose of pragmatism. Rightio, so thank you, Dorian. Andy, I'll hand over to you if you could come on board, and we'd love to hear what you've been looking at recently. Thanks.
Thanks for that, Brad. Thank you, Dorian. Today I'm going to try and navigate my way through the proposed safe harbour idea in the Companies Act legislation, together with the moratorium that the government has proposed to ease the burden on companies as they come out of this lockdown and start going back into trade. As we know, cash flow is king. Businesses need cash flow to survive. Not a lot of cash flowing at the moment around the place. And based on previous downturns, which I've seen one or two of, it will tend to be slow in building back up. Okay, so your fixed outlays don't stop. You keep going, owing rent, you're owing wages, you're owing your PAYE and all the rest of the business payments that I've gladly left behind and become an employee. So I've been there, done that, and actually, seen the downside after a business downturn and things dry up. Like in the employment area, the main thing is to be talking, and I can't stress that enough. You've got to be talking to your banker, you've got to be talking to your creditors, you've got to be talking to your staff, you've got to be talking to everybody to let them know that you're not just sitting there and hoping that somebody will wave a magic wand and everything's going to come right to you. So one of the things that will be worrying company directors in particular is I'm continuing my business, I'm making payments, I'm keeping my staff on because the government's generously thrown some money at me to allow me to do that. But I'm going to be in a spot of bother with my creditors at the end of this until cash flow builds back up. And some are nice and some are not so nice. So, somebody might start running around and knocking on the door with a Section 289 statutory demand when I'm overdue with a payment. And, what do I do? What can I do? The advice that we would give under the current legislation is, well, if you're trading whilst you're insolvent, and don't forget there are two heads to the insolvency test. One is, do your assets outweigh your liabilities at any time? That's if the assets outweigh them, your liquidity solvent. But can you pay your debts as they fall due? Is the one that trips most people up. The debt is due when it's due. If it's rent, it's due in the beginning of the month or the end of the month. Whenever it's due, it's due. Can you pay it? If you just box on and ignore the building up of time like that, you know that you can't pay these bills, you're trading whilst you're insolvent. You know that, and it's deemed under the Companies Act to be reckless trading. The downside of that, of course, is that if your company does go into liquidation, the liquidator conducts an investigation into the affairs and how the company was run, particularly in the last 2 years at the moment, looking to claw back any debts that might be preferential payments or anything like that they can get some money flowing through on a more equitable basis towards everybody. But if the liquidator forms the view that actually you've known for quite some time, because your accounts show quite clearly that you've been trading whilst you're insolvent, they can apply to make you personally liable as a director of the company for all of the company debt. And then the onus shifts from lifting the corporate veil to you fair and square, regardless of any other personal guarantees that you might have. So in America and in Australia, there's legislation in their corporate law that provides a term, what's known as safe harbour. Probably an apt name in these stormy times too, that you're all at sea and looking for a safe harbour to re-provision your ship so that you can sail back out when the water's calmed down a little bit. So what the government has signalled, and I stress here that what I am talking about is just what has been signalled and sort of promised, that some legislation is coming and will be backdated to allow directors to rely on a safe harbour provision similar to Australia's or New Zealand or Australia, America's. I'm picking that the Australian model was one that they will follow, and the intention of that safe harbour provision is to provide a better outcome for the company than the immediate appointment of a receiver or a liquidator would do. The downside of the liquidation, of course, is that the director's lost all control of the company. The liquidator is effectively shutting it down. A receivership's not quite so harsh, but you have lost your control, except you're still liable for the actions of the receiver as well, to a certain extent. The directors still have their director's duties, but the receiver is grasping the money as quickly as it comes in for the secured creditor. Whatever the safe harbour legislation will do, it will not extinguish, in my view, it will not extinguish any personal guarantees that you might have signed as a company director. So we're just talking about the corporate structure here. So the safe harbour will provide a moratorium, basically, against a receiver having a claim against the director for reckless trading if the director is in good faith, and here's this term good faith that we've been harping on about in our employment jurisdiction, in good faith believes that the company was solvent and will be solvent despite the current circumstances of the cash flow crisis that's making it technically insolvent. Now, if you were to rely on that, it would be my view that you would be required to take very, very stringent steps and have them very well recorded. You would need proper accounting advice that the company can recover and was solvent. You would need legal advice and any other advice from business advisors as to a strategy for heading towards recovery. It's not just a seat of the pants, oh yes, I'll be right sort of decision that a company director can make. It's got to be a robust and probably a very transparent process, because it'll possibly have to be subject to scrutiny further down the track if the company does ultimately fail. So you have an obligation to completely maintain all of your books, and that would probably go to almost doing a daily estimate of cash flow and statement of position, certainly weekly, and have a structured business plan in place for the recovery going forward. The issues that the company's facing would need to be identified, and I would suggest a strategy developed and put in writing as to the way the company intends to deal with them. And it must be undertaken as soon as the director realises that the company actually has solvency issues. It's no use going, well, I've sent out all these bills and they'll get paid, and you know, then I'll be able to pay this, and you're just postponing the evil day. And of course, it will never, ever extinguish any deliberate misconduct by company officers or employees for that matter. And I would also like to talk briefly about another program that the government is planning on bringing in, which is virtually a moratorium. You may have heard of a creditor's proposal under Section 14, I think it is, of the Companies Act, where if a company is in dire straits, it can come to the creditors with a proposal to pay a dividend, almost like a liquidation, but it's so many cents in the dollar, payable in whatever structure is achievable. And that provides protection from liquidation proceedings being commenced against the company itself. What's proposed here is not so much of a proposal to pay dividends at the end, as I understand it, but it's a pause and giving the company a chance to rebuild its assets, its cash flow, and to prevent any rash court action being taken against the company to prevent the build-up from occurring and the debts being paid. So it's assumed that it will need to be approved by a 50% by number and by value of the creditors. So that's a two-headed test. You might have 75% of the creditors by number saying, yes, we'll wait 6 months and work with you to get this. It's better to get 100% than to get 10 cents or nothing. But you may get a major creditor that says, no, to hell with you, I want it now, and if you don't do it, I'm going to have a go at winding up the company, or probably having a go at you personally as well. And I don't think, without seeing what the legislation may say about this, but I don't think a personal guarantee is going to be prevented from being executed against, or the effect of the personal guarantee that you may have executed coming home to roost either. But what it will do, hopefully, is buy some time for the company to probably review its escape plan. Again, it will have to be something that's done in good faith. I would think that you would be able to convince the creditors that, hey, look, we've got contracts coming in. We're going to be 2 or 3 months before we start generating some payments from those contracts. After that, the cash will start to flow, and we'd like some forbearance for 6 months. So it's something that will buy time without a formal structure, and allows the directors of the company to be the masters of their own destiny. It doesn't require an administrator, or it's not assumed to require an administrator. That may yet be shaken out in the legislation, but there's no hint that it needs to be a formal administration. But it will allow breathing space to allow a company to get back on its feet. So that's about all I can say in this format. It's something that a company will need to consider coming out of this. It looks as though it's going to be a staged recovery, or come out of lockdown in any event. So things will start to happen for those that will be able to trade under level 3 conditions, and then hopefully more being able to trade under level 2, and everybody back to whatever the new norm will be under level 1. So bear in mind that these things may be available for your assistance, and the government has promised the legislation, but only Parliament can pass it, and it's got to go through Parliament, unless we go back to the days of the good Sir Robert Muldoon and a midnight regulation is passed. But many a slip between cup and lip, and good intentions sometimes fall at the post, but it's something to look forward to. Over to you, Brad.
Excellent. Look, thanks, Andy. That was a very thorough and interesting presentation of those two areas, and obviously I think there's going to be a lot of interest and probably work in those areas for some businesses, and they're going to need to seriously consider that. Do you have any idea, Andy, what the legislative schedule looks like for that legislation, when we might see something?
They're talking about June, but that's only talking about, because who knows when Parliament's going to sit again and what process will go through. You know, will it be given urgency in the House? I would posit that it may very well be granted urgency and pushed through as fairly radical legislation. But Parliament is what it is. It's a bear pit, and somebody may get a bee in their bonnet about this and try to derail it or modify it or change it or whatever. So, yeah, the clear line at the moment is that it's hoped to have the legislation introduced in June. But as I say, that's all dependent on whether Parliament's sitting and what stage we are with lockdown. We could be back in level 4.
And Andy, I think I picked up in your presentation that you said that it's intended at this stage, at least, that this will be retrospective. Any idea when that may be retrospective to?
Yeah, when was that? They're hoping, I've just seen that they're hoping that the legislation will come in on the 17th of June, which may be a little optimistic. But
I think I may have seen somewhere the date, 17 March.
17th of March. Well, that's prior to the lockdown, really, isn't it?
Yes.
So that probably is looking at the normal cycle. I would suggest the normal cycle of bill payments and so forth, falling due on the 20th or going out on the 20th, whichever model you're facing.
Right, great. Thanks, Andy. That's excellent, fantastic, and no doubt we'll have some further discussion around that when we open things up. So thank you very much.
Thank you.
Rightio, I'd like to welcome James now onto the panel, and James is going to fill us in on some of the work that he's been doing recently, I believe, in the commercial lease space and what's been going on there. So over to you, James. Thanks.
Hello, everybody. I had the benefit of attending a discussion amongst a lot of legal practitioners yesterday to talk about some of the issues with commercial leases and rent abatements and no access and the other problems that every tenant and landlord is worried about at the moment. But just before I talk about these, it's been occurring to me that it would be very healthy for every business owner at the moment just to sit down and take a deep breath and make a very frank and careful assessment about the condition of their business. You need to think about your employees. You need to think about your obligations to them. You need to think about the condition of your business, its cash flow, as Dorian was talking about. You need to think about the insolvency matters that Andy was talking about. You need to think about whether you're going to be able to continue in business when we start progressing through the different levels of alert. You also need to think about your lease obligations. So please do find time to do that. It's very, very critical. Now, talking about the lease matters, it's almost certain that during this level 4 lockdown, that anybody who is not an essential business has very likely had a restriction in access to their premises. But that doesn't automatically grant anybody a discount in rent. It does turn on the kind of lease that you have in place. So for those people who have undertaken a lease using the Auckland District Law Society template document, 6th edition, which was released in 2012, there is some clauses dealing with a cessation of a fair proportion of rent and outgoings. For people that have the earlier version of that lease, then unfortunately you don't have that benefit of that provision. There's also the Property Law Council, the BOMA retail lease, which is quite common in shopping mall complexes. And that has some similar clauses in its more recent version, although they're a little more awkward to apply. So you definitely need to take some legal advice on those clauses before you would take a position. So focusing on the 6th edition of this ADL lease that I referred to a moment ago, 27.5 is the key clause, and it talks about non-access for the purposes of fully conducting your business. So some of the ideas that were discussed in the group yesterday were, what if you can operate your business online? Do you still need to pay the full rent? And that was dealt with by quite a lot of discussion, whereby people agreed that it's access to that premises that is the key issue there. So there may, when we come into level 3, if you were listening this afternoon, then when we go to level 3, people will be allowed access to their premises to conduct their business, but they won't be able to have contact with customers. So you might be able to access your premises to be able to conduct online sales or to do courier dispatches, but that doesn't necessarily mean that you will be conducting your normal business there. So that's when there's going to be potentially an argument on both sides of the table. Landlords, aggressive landlords, may argue that you do have access and therefore the provision at 27.5 no longer applies. And then the other argument from the tenant's perspective is, I do have access, but not to fully conduct my business. And unfortunately, there's no case law on this. The provision was put in after the Canterbury earthquakes, and inevitably some case law will come from this. So it's going to be very critical to try your best to negotiate in good faith to work out reductions. Now, talking about negotiating and working out reductions, it's occurred to me that if you do negotiate rent relief or discounts, then you should probably tie them to the alert levels rather than stating this month and that month. What is becoming clear is that at some unknown time in the near future, we will shift from level 4 to level 3. How long we will be in level 3 is unknown, and it's going to be assessed in 2 or 4 week blocks. We then may move to level 2, and depending on how that goes, we may go back up to level 3 or down to level 1. So I think it would be very helpful and practical if any negotiations are tied to those alert levels. So that might be, for instance, and this is just an idea, that during alert level 4 and 3, the rent is half. During alert level 2, you get a 20% discount. And they're just ideas I'm throwing out there, but they should be linked to those alert levels so that everybody knows where they stand and there's no need to renegotiate these things over and over again. The fair reduction of outgoings is a little less easy to work out. Outgoings in each lease will be different in the context of the building that you're in. There may be common power, there may not be common power. There may be insurance that is for the whole complex if you're in a multi-complex environment, or there may be insurance that's related to a sole tenancy alone. So I would suggest that some of those overheads, such as rates and insurance, are very, very fixed, and it would be unreasonable to expect a landlord to offer you a discount where they're not receiving one. However, if there are electrical contributions or marketing contributions or similar, which the landlord does have the power to decrease, then that's where there could be some flexibility in negotiation. Now, just because your lease may not have the clauses I've been talking about that the 6th edition does, doesn't mean you can't sit down and negotiate with your landlord, or if you're a landlord eager to preserve the tenant in your premises, you may want to grab the bull by the horns and sit down and talk, because your tenant might be too timid to come to you. At the end of the day, there's going to be liquidations. There are going to be firms going out of business. We've seen the receivership of Burger King, for instance, so nobody's immune. And that means most likely there will be quite a lot of commercial space coming up available for lease. So it would be, in my opinion, a bit foolish of landlords to be very firm in their positions now, because it may result in no tenant. And equally, tenants, you need to understand that landlords have costs in holding these premises. They have mortgages and they have to meet the OPEX. So if they're not getting the rent from you, it may be that you end up in a situation where they lose control of that tenancy, which wouldn't be ideal, I would imagine. So communication, 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 talk, 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 get deals done without resorting to legal conflict if you can. I think that pretty much concludes what I wanted to say there, Brad, and I'll hand back to you.
Great, thank you, James. That was a really good summary, and great to have the opportunity to get together with, how many people did you say were involved in that webinar? How many lawyers?
Nearly 1,200 lawyers chatting away.
That's a scary prospect for many, no doubt, stuff of nightmares. But for 1,200 odd lawyers to reach a commonality of mind or consensus on certain things is very heartening for me, and I guess it's symptomatic of the fact that everyone realises we're all in this together, and all of us, whether we be professionals, business owners, or whoever, has had to put heads together with other people to try and work out and navigate a way forward through what we're dealing with, as Dorian put, this unique situation. I'm just going to talk very briefly today about the employment law angle. As I said, both James and Andy join me in the employment law team at Godfreys, so I'm well supported there in the work I do, and they're very capable in their own rights and very experienced. So I'm very lucky we've got a strong team in the employment arena. We've had quite a lot of work in this space, helping many different business owners over the last 3 to 4 weeks, specifically around the wage subsidy application, what it all means, how to go about doing it, am I eligible, how can I use it, what can I use it for, and sort of every question under the sun. We've, of course, probably all heard stories of employers who've taken the money and run and done things with it they shouldn't have, and no doubt there'll be some accounting to be had once this all washes out. But by and large, my experience has been that many employers have treated their obligations to their staff extremely seriously, as they are required to at law, and have by and large abided by the obligations of good faith that are mandated in the Employment Relations Act, which underpins employment law in New Zealand. The central tenet of that Employment Relations Act is the concept of good faith. It's a word you've heard other presenters and panellists use today, and it's a word we've been talking about in webinars past. Good faith, essentially, to me, breaking it down to very nuts and bolts, is communicating with one another and listening. So if you're an employer and you're proposing to do something, you just can't carte blanche do that without communicating your intention to do so with your employee, and then expect them just to toe the line and fall in and be happy about whatever change you've decided to make overnight. Having said that, and there's always caveats and caveats with everything in the law, including employment law, certain employment agreements allow employers to do certain things at their discretion. But where an employer is proposing to make a change that would impact or affect an employee's essential terms and conditions of employment, and they are probably broader than many people imagine, and go to things obviously such as pay and conditions, but also hours of work, break times, many different things. You just can't simply change those willy-nilly without consultation, because if you do, you could be staring down the gun of a personal grievance claim from your employee or employees for subjecting them to an unjustified disadvantage, and at worst for causing a constructive dismissal, depending on the severity of the action you've undertaken without consultation. So jumping back to this concept of good faith, it's really quite simple, but it requires open and honest communication. If you're proposing to do something and you're an employer, which I presume most of you here attending today will be, if you want to make a change or need to make a change due to the current scenario, then you're going to have to consult with your employees over that. You're going to need to make your communication clear in what you're proposing, and you're going to need to give your employees the opportunity to comment. That's known as consultation on what you're proposing. Of course, given the times we're in, the requirement or the length of consultation period may be slightly compressed than usually would be the case in more normal historical times, but nonetheless, you've got to give them fair opportunity to comment. and that requires time for them to think about it, take advice, should they wish to do so. And a really good option that I advise my employer clients when putting any consultations out to employees is just to let them know that A, they can take legal advice, and of course not all employees will want to do that or indeed be able to afford to do that. But secondly, that MB has a free employee info line on 0800 20 90 20, and you can give that detail to employees. And I think that's showing good faith, that you're not just simply trying to ram a proposal and speed it through, but you're also giving them the opportunity to go away and take advice should they need it to find out what their rights and what your obligations are. So that's the opening comment I'd want to make there. Probably that feeds nicely into the next comment, and no doubt many of you would have heard this by now on the news and in articles you've probably read online and LinkedIn and across various media, is that just because we're in unique times in this pandemic situation, it doesn't mean that employment law in New Zealand has suddenly been suspended overnight. That is not the case. There has been no overarching or sweeping change to employment law that I'm aware of, meaning that these obligations that I've just outlined, the duty of good faith, the duty to consult and get feedback on proposals, and to get your employees' consent to your proposed changes or anything you're looking to amend in terms of their essential terms and conditions of employment, that still holds true. You can't ignore that. If you ignore that, you do so at your peril, and you could find yourself in pretty hot water. So whilst you might be able to run slightly compressed consultation periods and timeframes for any changes you may need to implement to keep your business afloat and surviving through these times, you ignore employment law at your peril. And look, I've been heartened by the fact that, as I opened with, many employers and business owners I've been speaking with during this period of lockdown at level 4 have taken their obligations very seriously. They've been taking advice, and they've been very concerned to make sure that they get it right, both for their business and for the sake of their employees and their livelihoods and their families, which is is fantastic. And I think that's been, for me, probably one of the more heartening things of this whole scenario, one of the silver linings, if you like, that the message of be kind, which is really just another expression to me of good faith, is what it's all about, is getting through this together. Of course, bearing in mind those serious legal obligations that directors and business owners must adhere to and pay heed to and think very seriously about, as James talked about and Andy's touched upon. But take a breath when you're looking at making any changes with respect to your employees, especially if you're looking at implementing or invoking a force majeure clause, for example, in your employment agreements. If you have one, they're pretty rare, but they do exist. I saw one in the last week. And there's been a lot of discussion out there in the media about those and when you may look to use those as well. And they're not a silver bullet in my view. And all of them start and finish largely with their own wording. So it's always critical to take a good hard look at what your employment agreements say as a first step before you undertake any steps moving forward in any area of your business with your employees, if you're wanting to make a change. And if you're looking to restructure, if you've taken the subsidy already after the 27th of March, then you're going to have some issues doing that within the 12-week period if you've already got that subsidy. So that really is an area where you're going to need to take some detailed professional advice before you commit yourself to a particular course of action. So that's probably all I want to say at this point in time, and happy to address any questions as they come through, as no doubt the panellists will be on the employment front. We've already had a couple. But that's it from me. So look, I'll just throw it back over to the panel now. I'm just interested, I know there's already been some discussion. I seem to have muted myself. No, there I am. I've already been some discussion about level 3. So just interested to hear any input, Dorian, Andy and James, you may have about what your feelings are on level 3 and for business owners moving forward.
I'd like to make a comment about level 3. I noticed there was a particular point made by the Prime Minister this afternoon that malls will not be open in level 3. So a lot of businesses in Christchurch are based in malls, especially retailers. and more landlords are drawing some pretty tough stance on rent relief, as I've heard through the media. So once again, sit down, review your lease documents, review your supplier contracts, review your employment agreements, and really consider what you need to do and take the relative professional advice.
Thanks, James. Great. Anything from you, Andy?
My view is that level 3 will shake out when it arrives as being not much different from level 4. It was quite clear from my interpretation of the Prime Minister's musings this afternoon that if you can work from home, continue to do so. If you are going into your office or your business, it's not open slather on face-to-face contact with clients or even probably with other staff members. So it's a slight easing. It's allowing a little bit more freedom of travel and allowing people to go and have some more recreation as long as it's non-motorised. But it will be a very gradual wind back, as I understand it, or I'm apprehending. And I think everybody's got an air of expectation that next week they're going to announce that on Wednesday it's back to level 3. I mightn't be too sure about that because I think there's some pretty bad behaviour shown about people escaping or trying to escape lockdown for Easter weekend, and we've got another weekend coming up, long weekend coming up with Anzac Day, and the government may very well say, well, no, we don't want people running all over the country, and that was another thing that she was talking about quite clearly. You know, you stay within your geographical areas. If you live in Auckland, don't go to Hamilton. If you live in Canterbury, don't go to Otago. You know, so they may want to make that just a little bit more clear by saying, right, well, this will kick back in after Anzac Day. So I wouldn't be surprised if that's what happens, particularly given the school kids. There's been a clear start date of 29 April mentioned for a gradual return to schools. So that's post Anzac Day. That's just my thoughts. Back to you.
Thanks, Andy. I'm stoked at the prospect I will be able to go surfing moving forward. Being a keen surfer, obviously the surfers have made the news for some of the wrong reasons recently. There was a flouting the lockdown, but it'd be great to be able to get back out in the ocean. Andy, my understanding was under this relax, or under alert level 3 that the Prime Minister has talked about this afternoon, that tradies may be able to go back to work. What was your understanding around that?
Yeah, it was, the intention was that if you can't conduct your business from home, now tradies, construction guys, that sort of occupation where you're hands-on mechanics, hands-on stuff is not conducted from home. You can't sit in the kitchen fixing a car because the person can't get it to you for a start. The construction boys will want to be getting back. The developers and so forth will want that to happen too. So it will be a gradual weaning back into the new norm. Now that even though the tradies may be back at work, they've still got to maintain the social distancing, and it's not going to be like it was.
Mm-hmm. Right. Okay. Great. Thank you. That'll be heartening for many business owners. I know I deal with a lot of people in the construction industry, so that'll be good news for them. But obviously, some restrictions and parameters around that, as you've just mentioned. Dorian, any thoughts from you about this level 3 and what that might mean for businesses and business owners?
Yeah, and just taking back and extending on what Andy said, the reason that the construction industry is able to go back is that it's got no client facing. That's really what they're saying. And linking into what James was saying early, you know, if you've got a business that you can actually operate from behind closed doors, so to speak, then you should be able to operate under the level 3 with your proposed accreditation. So if I'm a business owner and I'm sitting there, and if I have a premises or you know, however I operate, I'd be seriously thinking, well, if I can operate without any client facing, what does that look like? What technical support do I need? What IT infrastructure do I need? Because the IT guys, they can do all this behind the scenes. You know, what do I need what's employment, or do I need a different skill set for my team? Who's best suited for this? Where does certain people, members of the team, fit in? Because some people might be working there, but some people are sitting at home. And I know that I've heard of friction where some members of the team are getting 100% of their salary doing nothing, and others are working extra hard. So, you know, there's all these things in play, but realistically, it comes back to a common theme that you've said, that Andy said, and then James has said, is communicate and look forward. Communicate with your suppliers. How can we get deliveries? Contact us deliveries. You know, how does this all work so that when level 3 comes, you're actually in a position to enact your plan? And I know Andy was talking about that in a wider scheme as far as looking at liquidity and cash flow and what have you. But, you know, if you're really wanting to succeed under level 3, it's no use getting there and then going, oh, right, what sign do I put on the door? And then spending the morning figuring out what, and these things happen. People, you know, reinvent on what sign to put on the door. Now, if that's all there, you get there, you slap it on and you're into it. Use the time that you have to really work on what stage 3 looks like. Okay, and that would be where I'd be looking to be working with my clients. What things do you need in place? And Andy was saying quite rightly that, you know, for you to safe harbour, you need to have proven that you were good going in. And I think 31 December, I think, was a date that I saw. So, you know, I've already prepared some interim financial statements for some clients for 31 December, proving they're solvent, just getting that duck in the row so that we might not need it, but it's there if we need to. You know, I've had clients already saying, hey, look, well, I'm at home, I get the records, let's get my 2020 tax returns and financial statements. It sounds mad. Who wants to do accounting stuff now? You know, the sun's shining. But at the end of the day, it's getting these things in order. So you've got the bits of paper and support for your accreditation, your processes and your policies, all these things. So you're good to go, because you don't want to be a laggard. You don't want to be a laggard. You want to be at the top of the curve. So that's all I'd say about being in business and looking forward to level 3.
Thanks, Dorian. Some really good material on there. You've got to be in to win, and from my perspective, in this environment, moving down a level, you want to be as well prepared as you can to hit the ground running.
I'd like to make a comment, if that's all right, Brett.
Of course, go for it.
Yeah, so just with my business owner hat on, the thing that upset me today when I was listening to the Prime Minister is that there was no indication of how long level 3 might go on for. So you may find yourself looking to consider your e-commerce platform options. Some people have got online websites which are able to process sales through platforms like Shopify. It really could be a good opportunity now in this next week or so before level 3 to consider those options. It's very unhelpful not having any idea how long level 3 might last for. If it's going to last for a few weeks, then many people could probably suffer through that pain. If it's going to last for 3 months or more, well, then that could entirely change all the decisions you need to make right now. So my gut instinct, and it's just my opinion, but I think that level 3 will go on for considerably longer than level 4. And so I think you should make your decisions based on how long you think you'll be in this odd status of online trading only for those people that are not essential.
Yeah, I guess that's a real case of plan for the worst, hope for the best, isn't that right, James?
Thank you, James. There's some good thoughts and tips in there. Look, I think now what we'll move to do, we've got a few questions for the webinar. Some have come in before today's webinar via email, which we've got sat here, and we've had some questions on the screen. So look, I'm just going to fire some questions out at the panellists now, and if you'd like to pick up that question, maybe just unmute yourself and have a crack at answering it. And if someone would like to add anything to that panelist comments, feel free to do so after they've concluded their comments. Rightio, so some commercial questions here. So there's been, this question here has come in via email. There's been a lot of uncertainty over the rent payable due to the lockdown. I'm in the process of releasing some commercial space. So what should I do as a landlord to try and avoid in the future the problems which everyone else has had over this issue? And what would you be telling me if I was a tenant about to negotiate a new lease? So that's an interesting question. Anyone like to have a crack at that?
I'll have a go. I'd like to do this in two parts. First of all, for any existing lease arrangements with landlords and tenants looking about how to negotiate this discount if you are fortunate enough to have the clause 27.5 abatement, each situation will be different. And so the landlord will need to consider the situation for that tenant. And I would suggest that if you're a tenant looking to put a position forward to a landlord, you want to be able to base it on logical foundations. So if you've got a retail shop that you're paying $300 or $400 a square metre for, that you cannot use to sell those goods, then really it's only a storage facility. And I would be putting an argument to the landlord that, look, I could be paying $100 a square metre for storage space. That's what I've in effect got. Therefore, that's what I'm prepared to pay. If you can found your position in a sensible argument like that, then it will be very hard for the other party to say, well, that's not fair or that's unreasonable, because in actual fact it is very well founded. So try and think laterally like that. For anybody looking to enter into a new contractual relationship, and what has become obvious in the intervention by government, shall we say, is that they're far more eager to intervene with residential tenancies than they are with commercial leases, and that is because commercial leases are more of a contractual relationship that should be left for the parties to work out. So you could look to add a clause to a lease through your lawyers, of course, so that it is worded properly, which has a mechanism in it for calculating rent abatement or discount in these sorts of situations. We've had the matter of the earthquakes. We've now got the pandemic. It seems that these events are becoming more frequent, and so it probably is a good idea until there's a table put in by the template makers to look at perhaps preempting some of these scenarios with a mechanism by which to calculate discounts in certain situations. It's very hard to anticipate everything, and that's why it's a little hard to apply clause 27.5 to this current situation, because it was worded based on the effects of the Canterbury earthquakes, and the drafters hadn't fully turned their mind to a nationwide pandemic scenario. So what you think of today might not be relevant tomorrow, and what happens tomorrow you might not have thought about today, but you could try to put some mechanisms in for valuation purposes.
Thanks, James. That's some good advice there. What about 27.6 and the interplay of 27.6 for any parties who might be looking to enter into a new contractual leasing arrangement? And 27.6 refers back to the first schedule and the no access period, which typically in the template is a starting position of 9 months. So what would you be looking to do if you're a landlord or a tenant in terms of that no access, the length of the no access?
This issue came up yesterday, and amongst all of the lawyers that were chatting, and there was a view that because level 4 and level 3, as we know it now, could run on for some time, anybody that has 9 months or even less, I have seen a lease recently that had only 3-month period in the schedule, there may be a scenario, 27.5, and the fact that there is restricted access and there may be a negotiated discount would give rise for either party to terminate based on 27.6, and we're talking about the 6th edition 2012 version of the ADLS lease here only. It may be an unintended consequence for either party that there's the opportunity to terminate this lease based on that provision. So everybody who was talking yesterday thought it would be a very good idea that any negotiation is done as a variation to the lease, and you may want to specifically state that you are removing 27.6 or agreeing that it will not be activated by either party. So do think about that, and lawyers will help you draft it.
Great, thank you, James. All right, look, I think we'll move on to the next one here. The question is, if my landlord reduces the rent during April, is this a remission of debt which creates a tax problem for me? Dorian?
Okay, the short answer is no. Okay, I won't get into technicalities behind it, but effectively, the IID won't penalise you if you pay what is due and rightly payable. At the end of the day, the trouble would be if you accrued the rent payments or the deferred payments on an accrual basis. Getting very techie here, and then decided that the landlord forgave half of it. You've already taken 100% deduction, and therefore, realistically, you'd have the other 50% would be clawed back by the revenue. But basically, if you're just paying what the landlord's asking you to pay, and you're not accruing an additional expense into your financial statements, then no, there shouldn't be a tax issue.
Great, thank you, Dorian. Very clear. Rightio, here's a question. Is it too late to apply for the wage subsidy?
No, is the short answer. Again, I was assisting someone this morning. One of the technical points that seem to be trapping some small traders is that they're using their personal details when they operate through a corporate structure. So just remember, when you're applying generally you're applying under the company name at the top, and your personal details are the employee details down the bottom. So that's the only fishhook I've seen. The other thing is that there have been some delays in the processing. Don't constantly ring your accountant. There is nothing we can do. It is just sit on the 0800 number until you get through to someone that's helpful. There's no, like with income tax, we've got special lines we can call, but with this, there's nowhere we can go. So, but the short answer is, if you do think you're going to meet the criteria, then sure, yeah, get in, get some assistance for those wages and keep people employed.
Great, thanks, Dorian.
And don't forget that self-employed people are able to claim that subsidy as well. That's something that may be overlooked by some sole traders.
Yeah, true. And depends. There are plenty of little fish hooks around it, but Andy's spot on. If you are sole trading, don't feel that you're not entitled to it. Get stuck in.
Great, thank you. Here's a next question. Can I invoke a force majeure clause in my employment contract to terminate my staff? Let's have a go at that curly one.
My understanding is that this force majeure has never been tested in the courts. So if you want to make law, give it a go. But I think it would turn on good faith negotiation. Sorry to keep harping on about good faith and negotiation, but that's the way that that an agreement may be reached that prevents the sharp end of an employment grievance coming your way. The force majeure clauses are in there, and not too many employment agreements that I've seen, and as far as I'm aware, they haven't been tested in the courts, and it would be, I think, a brave employer that tried to invoke that at the moment, given the current circumstances. But
right.
if it's the other option, of course, is redundancy. The same outcome may be achieved by different means.
Great, thank you, Andy. Rightio, so just got some Q&As here. So this query is coming online to Dorian. Can you elaborate on the cashback discussion from IRD on tax paid? How would this work practically?
Yes, this is one of the ones where the government grandly announced this, and then everybody starts to scramble behind the scenes. Effectively, there's two ways that you can achieve unlocking some tax payments. Is if you made a loss in the 2020 year, and then you can apply that loss to a past profitable year. I can see that being useful for some clients. So effectively, if you make a $50,000 loss this year, you made a $50,000 profit last year, then effectively you could offset those two. Say my income for the 2 years was zero, I've paid this amount of tax and get it back. There is absolutely no detail in the legislation about how this works, how if income's passed out to shareholder employees, does it look through, anything like that. One of the more dangerous things that I think they're talking about is that you can predict your loss for the 2021 year and apply it to your 2020 year. So you might say, well, next year I'm going to make a $100,000 loss, apply it to this year, yay, I've got no tax to pay. The IRD have said that's fine, but there will be, if you get your loss estimate wrong, at this stage they're looking at shortfall penalties and use of money interest. So I'd be pretty twitchy about forecasting losses in the future, unless you happen to be in tourism or something like that, in which case I think obviously it would be relatively easy to forecast some losses. But practically it's really looking at the 2020 year and accessing it. My concern is that if you're accessing, if you're anticipating large losses, any tax that you get back will not cover the losses that you're going to incur. So you might end up, and Andy, you probably want to dovetail in on this, where, you know, at the moment you go, yeah, I've got some tax losses back, I'm safe harbored, I reckon I can go on, but really all you're doing is providing a couple of months of cash flow, and you stagger on an extra couple of months at the end, and I'm not sure how useful that could be. Could be really good, but it's how the devil in the detail, and there might be some fish hooks. But Andy, what would you think about the knock-on effect of a company that's staggering along, get some tax? You know, it's not going to be a panacea. Where would that sit with insolvency?
Sorry guys, technology confusing me. I would think that as long as you had gone into the safe harbour in receipt of good advice, which would include accounting advice along the lines that you'd given, and the forward projections still looked okay at the time you entered safe harbour, the safe harbour could continue. It's only a short-term period for protecting any creditors that are paid and preventing a claim of reckless trading. Now, obviously, to go into safe harbour, I'd say that they've got to have received proper advice, both certainly accounting and business advice from any other financial advisor they may be doing, such as restructuring advisors and the like. And that could include solicitors. So you've got your plan. If you've got your plan and you're relying on it in good faith, the fact that what you projected didn't come through, I don't think would be able to be held against you, because at the time that you entered the safe harbour arrangement or invoked it, you did so in good faith. That'd be my view. Thanks,
Andy. Just one thing, and I did get asked this the other day. I made a small loss last year and I've got a loss this year. Does that help? The government aren't going to give you tax back you haven't paid. Okay, I know it sounds simple, but the short answer is they're not going to give you something you haven't already paid them. So just throw that in the back of your mind.
And I don't think you could enter safe harbour if you'd made a loss last year and we were projecting one this year, could you? There must be a solvency question creeping along behind you.
Well, if you've got a large overdrawn current account, generally you're pretty solvent, Andy, because your assets are often larger than your liabilities. But I'm being tongue in cheek because
not when they crystallise.
Anyway.
Right, thanks, guys. We've got a couple of employment queries here coming up. So this question that's come in the Q&A during the webinar. Brad, you mentioned consultation. How is that practically outworked when employees are all working from home? Email ? Individual calls ? Yeah, so look, but my view on that is, it comes down to personal style and preference. I'm a big fan of personal contact, and what I mean by that is either a phone call or a Zoom chat, a face-to-face. I think there's still real value in that in this day and age, even though we're technologically advanced supposedly, and we can fire off an email at the shot of a button. The danger, of course, with emails is once it's committed to writing, it's there and it's gone. That's not to say you can't retract any boo-boos you might make in an email or any changes you might want to update. So look, it comes down to personal preference. I know many employers have been doing it by change suggestion to their staff via email, and depending on the size of your workforce, that may be the most practical and efficient way to do it. If you've got a smaller team, I'd be recommending the personal touch if that's your style, your personal style, picking up the phone or having a Zoom chat with the whole team if that's practical. Once again, just to talk through any proposals so everyone can hear it at once. And then follow that up with an email, I think would be a sensible way to do it. So that's my thoughts there. There's a second part to that question, and I might throw this over to you, James and Andy. See if one of you would like to have a go at this. Given the requirements on physical distancing in workplaces, how much flexibility is there to enforce separate shifts and change break times, etc.?
I think that would depend pretty much on what your individual agreements were as to how flexible they were. But this is sorry to keep harping back to the magic word, negotiation. I'm sure the workers want to get back to work, productive work, and hopefully, coming out of minimal wage or less, less wages than they're used to, and wanting to build back up their cash. So most workers would see the sense in making it work. It is dependent on what's in your employment agreement, but there's got to be some flexibility and good faith between two contracting parties in that regard. So I would think that unless there's a prohibition in your employment agreement, anything's on the table for negotiation.
And obviously, in line with the obligations under the Health and Safety at Work Act, the employer's going to have to think pretty carefully about that in terms of how they manage that with any sort of return to work.
Yeah, well, that's paramount. And also, there's the other bogey, of course, that the Health Act may still be invoked in this stage 3, stage 4 stuff. So a medical officer of health might come in and wave a big stick as well. So, you know, the prying eyes of the state may still be peering over your shoulder, and I'm sure that no worker or employer is going to want their enterprise shut down because they're not abiding by the play fair rules.
I think the Health and Safety Act comment is quite important there. It would be a reasonable instruction from the employer to the employee to shift their break time so that they don't happen at the same time for staff members, and you know, simply for those health and safety purposes. And I don't think the Employment Relations Authority, if a matter got there, would find trouble with that. What do you think, Andy?
Yeah, I don't think it would get as far as the Employment Relations Authority, but James, it would also be dependent on the size of the enterprise that's going back. What about Watty's factory with, you know, 200 or 300 people on the factory floor at one time? What are you going to do? Separate morning tea times for each individuals, or blocks of them, or whatever? It's all got to be negotiated, and it may be that they have to take breaks at different parts of the organisation rather than going to a common smoko room. There are ways around it, but it is I don't think it's something that an employer or employee should be scared of, sitting down and having a chat and saying, how can we make this work? I'm sure the unions in a large enterprise would be right behind trying to make it work too. They want everybody at work. So does the government, by the way. That's what the wage subsidy is all about, keeping people in work. That's my view.
Thanks, Tim. I've got a question here, which is going back to the wage subsidy you've just closed with there, Andy. So the question that's come in via email, to work out average hours for a casual after-school employee, do we do this over a 4 or 8 week period, which was an example given on the government website, or a 12-month period? Any thoughts?
My thoughts would be, well, where's the starting point? How long have you had this particular employee? If you've got 12 months, I think the material that I've seen suggests a 12-month period to give you a proper average. It's just a question of common sense. If somebody's been there less than 12 months, it's just the best average that you can get. An average is an average. It doesn't matter what you're, well, I suppose it does matter what measure you're taking, because if you can be selective, but if the employee has been there for 12 months, that's the rule that I saw in the original documentation that came out about it. Back to you, Barry.
Great, thank you, Andy. So we've got, I think this is our final question thus far, unless any further questions come through on the Q&A. So if you have any questions you'd like us to answer, file them through now and we'll do our best. But for now, this is the last one I think we've got. This question or comment is, I've heard something about depreciation coming back in. What's that on, and is it the same as in the past? What does that all mean, Dorian? Any ideas?
Yeah, so it was one of the early announcements in the first response to the COVID, their first sort of COVID response package, that they got over 10 billion. It was actually going to be announced in the budget anyway, and so they brought it forward to package it up, I think, political reasons. But however, that's a thing set aside. Effectively, what they've said is that they're going to reinstate commercial property depreciation, and I think it's from the 2021 financial year. So whilst it won't provide any direct downstream effect to a lot of businesses, to owner-occupiers, and I guess the theory is, does it take pressure off rents? Or does it just increase the return, or does it make it more palatable to build some more commercial? But yes, the long and the short of it is that the depreciation that was struck out has been put in for commercial businesses, buildings, still does not apply to residential. So don't, if someone says down at the pub, oh, it's great that we're getting to be able to depreciate our buildings again, like at the end of the day, that's only for commercial buildings. Generally, there's still a lot of fit out that you can split out on both commercial, still available on residential rentals, and there's some specialist advice around that. So, but yeah, so the short answer is yes, it's back. Is it going to be a lifesaver? No, but certainly be good for commercial property owners in the future.
Not forgetting, Dorian, that it's only a deferral that comes back to bite at the end.
Well, my entire career is built around deferring tax, Andy. Why pay anything today when you can defer it out 10 years? But you are correct. It's like any depreciation. At least you knock it down, in which case you get a nice deduction. But yeah, no, you are right that any of those sorts of tax adjustments are often just a deferral mechanism, but one worth always taking.
Yeah, it's like the barrister's favourite tool, isn't it? Delay, delay, delay.
Thanks, gents. I've got another question that's just come through on the Q&A, and this question, I'll throw it open to all of you. If I applied early for both the wage subsidy plus the leave subsidy before they plugged the gap in the subsidies, should I expect to receive both? I've applied for both for 18 people, received one payment of subsidy for 19 people.
I'll have a go with this.
Thanks, James.
I am aware of cases of people that have made application for both. Some people have been paid both. Some people have been called by Work and Income who are administering the scheme and have been told that they're entitled to the wage subsidy but not the leave payment. Those people who I know of that have received the leave payment as well have received it for the 2-week period only. So I'm not sure whether you should be contacting Work and Income to hand that back or not, but certainly you would definitely be obliged to distribute it to your staff members.
And don't forget that the change making just the one payment available came round to stop double dipping. So that they obviously became aware of exactly this scenario. And I would suggest it won't be too long before somebody is ringing up and saying, "Oi, you, we want some money back, please." Just a thought.
Thanks, Andy and James. Yeah, I guess if in doubt, maybe the safest thing to do, one or two things, is either park that up, the double payment, or get in contact to seek some guidance, perhaps. Rightio, look, that looks like it's all. Hang on, we may have just had another question. Okay, so the question's just come through. Can I just pay my tax late this year?
I guess that's one for me. The short answer is if you do it correctly, there is a deferral mechanism. So basically, early on, they said, look, you just let us know, defer it out, and just give us a time frame, and everything will be fine. And it was that lasted about 3 or 4 days, and they said, no. What we really meant to say, so it's like a Trumpism, was the fact that if you contact the revenue and set up an instalment arrangement, penalties and interest apply. However, when you've paid the tax, the core tax, you then say, look, I was affected by COVID, and they will write that interest back. So it's a sort of, yes, you can pay it late by the usual mechanisms of instalment arrangement or Tax Management New Zealand tax planning. But yeah, so just don't go, oh, I don't have to pay it. it comes back to what James, Andy and yourself said. IRD is just the same as anybody else. You just got to communicate to them what your plan is. And if you use, just as an aside, but practical, the My IR site where you just go in and apply for an instalment, you're acting with a computer algorithm. Take the time, ring up and speak to a human, because then you'll be able to get payment holidays and work, and be a lot more flexible for you.
Excellent. Thanks, Dorian. I've just had another question come through in the Q&A. In a partnership business of husband and wife, do they only receive one subsidy?
No, the subsidy is per employee. So if they're a husband and a wife both working in that business, then what will be the question is, are they working for more or less than 20 hours each? And there is a caveat I recall, and Dorian probably knows as well, but you could not have been working for more than 20 hours if you weren't at least paying yourself the minimum wage for those hours. I think there was a caveat there, because a lot of partnerships and owner operators may actually put in 50, 60 or 70 hours a week without actually getting paid for all of those hours.
Yeah, that was my understanding, James, that there was some minimum payment requirements. So I do know people that have registered for PAYE and putting through a minimum payment. And because it doesn't effectively affect their tax position, but it just clarifies for review if they're doing that. At the end of the day, I guess if you're under 20 hours, I would be surprised if they got that granular in their investigations. The idea of this is to keep the money in, as Andy said, keep people in work and get cash moving around the economy. I think if you basically, if you both applied for full time, and she was also working at or he was working at the front desk of somewhere else part time, and they're also stocking shelves at night, and they're sort of triple dipping effectively, I think you might find there'd be some issues there. But it does come down to that 20 hours or more. But certainly, if you've only applied for the main employee of that partnership, feel free to go back, and because generally the other person does do a lot of the back end book work and assistance in the back, which can add up to quite a few hours. So yeah, I'd be applying in the background for the other person.
Great. Thanks, Dorian. Thanks, James. So look, that brings an end to the questions that have been posed. So thanks for all your answers there and insights. That's fantastic. So look, I think we'll look to bring things to a close. And I'd just like to thank everyone for taking the time out of your day to join us this afternoon for this live stream webinar. I hope that you've found some value from our presentation. If you'd like to get in contact for a chat with any of today's panellists, then for Dorian, head to www.pkfgf.co.nz, www.pkfgf.co.nz, and you'll find his details and smiling picture there on the website, as well as his varied and capable team. And for Godfreys Law, www.godfreyslaw.co.nz, where you'll find details for Andy, James and myself. So moving ahead, we will be hosting a further live stream webinar, same time, same bat channel next week, with our views and insights. So if that's of interest to you, we'd love to have you back at that time. So in closing for today, be kind, stay safe and well, of course, and keep on taking each day at a time, and I'm sure together we'll get through. If you'd like any particular topics to be addressed that might be of interest to you, then please feel free to drop me an email at brad@godfreys-law.co.nz with any suggestions you might have. But aside from that, thanks for your time today and thanks for taking part. It was great to have all your questions, and hopefully we've been of some value to you. So thank you, Dorian, for your insight and acumen. Thank you, Andy, and thank you, James, for your insight and input today. I've enjoyed my time with you. Thank you very much. Cheers.